Hello, I'm Daniel Rhodes, and I'm an attorney, but I'm not one of those attorneys. At Rhodes Law Firm, we don't sue anybody. We do one thing, and it's the same thing that we've done for almost 40 years, and that's help prepare you and your family for that time in the life of your family when you may not be there, either because you've become incapacitated for some reason, or maybe because you've passed away. And so really what we try to do is help prepare or put a plan in place such that you can take care of your family even after you're gone. And you want to have your family treated just how we would treat our family. And we view our clients as an extension of our family. And so we want to make sure that they're as taken care of as we are. And so when we talk about putting a plan in place, doing things ahead of time is really what we're talking about. And also we're going to talk about wills and trusts, estate planning in general, the power of attorneys, probate, long-term care, and the expense associated with that long-term care, and maybe some ways that we can protect your assets from that cost of care. By watching this video, you're entitled to come in for a free consultation with me or one of the other attorneys in my firm. And that's a 2-hour consultation. It's worth about $600. We'd encourage you to take us up on that offer. There's no obligation to go forward at that time. I'm not the only attorney with Rhodes Law Firm. There's also my father, Aubrey Rhodes, who's been doing this a little bit longer than I have, and also my associate attorney, Colby Bushelon. And we all do things the same way. And that's part of our plan. We encourage our clients to plan ahead, and so we're also making sure we plan ahead. So that if something happens to me, there's someone else that can step in and fill my shoes and help my clients immediately. Because we all do things the same way, and we're all keeping a system in place such that they can access the information I have, and I can access the information they have. So no matter who you work with, you're working with the Rhodes team. A lot of people hear the term estate and they think some large amount of land or a bunch of money, but that's not really what we're talking about. What we're talking about is the stuff that you have. You know, it's maybe the stocks that you own, maybe the house, the car, the cash and savings that you have, all of these things that's yours. It's your stuff, and that's our legal definition, your stuff. Tonight, when you think we're going to be talking about just your stuff as an estate planning seminar, that's not really what we're talking about, because there's one asset that usually is more valuable to you than your stuff, and that is your family and your family harmony, something you've worked so hard to build over the course of your life. And so tonight, that's really what we're going to be talking about, is how to preserve that family harmony well after you've passed away. When someone comes in to see us for a free consultation, they typically have one of two plans. The first is the die and hope for the best plan. And as you can imagine, that has a lot of drawbacks. And so we're going to talk about those in a little bit. But first, we'll talk about the more common plan, which is the piece of paper plan, a will. Most people, when they come in to see us, have a will in place. But really, sometimes it's not even worth the paper it's written on. For example, it puts off work until the worst possible time in the life of your family, right when someone's just passed away, because all it says is, after I pass away, this is where I want my stuff to go. It does absolutely nothing to back up all the information you have in your head. You know where all your bank accounts are, you know where all your stuff is, but your spouse, right after they've just lost you, may not be able to remember exactly where everything is. It's a tough time, and this will does nothing to back that information up. Also, a lot of the attorneys that'll help you put together your will are not the same people that will help your family administer your estate after you've passed away. It's usually something like a real estate attorney. You've used them in the past to close on a house or close on some piece of real estate, and so you feel comfortable going back to them and asking to help to put together an estate plan. And they'll help you draw up a will. But because they're not doing estate planning as their primary business, they typically don't have the time to help your family administer your estate after you've passed away. And so what we're left with is have to try and find someone that can help, maybe through Google or the Yellow Pages. And that's a tough time to try and find someone that you can trust through Google. A good estate plan also needs to be maintained over time. If you put it in place and you put it on the shelf, it is surprising how quickly 10 years will go by and you haven't done a thing with your will. And as you can imagine, the world changes over 10 years. The law has certainly changed, but also your family has probably changed. Maybe you've had births, maybe marriages, maybe divorces, possibly deaths. And your will has done nothing to reflect that if it's been sitting on a shelf. And what's more is your family may not have changed all that much, but your feelings towards your family may have changed. And again, the will not reflecting those feelings being changed may create a mess when you pass away. Sometimes we'll see when you put a simple will plan in place, also a simple power of attorney. These power of attorneys that are prepared by other attorneys that don't do estate planning typically are not complete enough and leave your family scrambling at that time when you've become incapacitated. And so What you really need is to have a very complete power of attorney so that we don't end up having to get guardianship or conservatorship over you to try and help. What happens if you need long-term care? Who's going to pay for that? The will does absolutely nothing. All it says is, after I pass away, if anything's left, it will go to my family. But the will does nothing to make sure there is something left after you pass away. Typically, an attorney who doesn't do estate planning will purchase a form document that they will put your name into, essentially, and they may do a little bit of hand editing. But usually it just says, I want everything to go to my spouse, if then living, and if they've predeceased me, I want it to go to my family, this way or that way. What usually happens is the attorney didn't realize there were more opportunities for you to take advantage of to take care of your family after you've passed away. And so they've given you a very simple one-size-fit-all plan, when really no two families are just the same. Your will doesn't actually cover all of your assets. There are large groups of assets that are not covered by your will, and that's anything that carries a beneficiary designation. A good example of these assets would be life insurance, retirement accounts like 401ks or IRAs. Also, annuities carry beneficiary designations. Anything that has a beneficiary designation does not get covered by your will. Instead, that beneficiary designation says where it goes. And as you can imagine, that can create some problems, because during the course of your life, when you're signing up for that new 401k at that new job, you're not thinking, how does this beneficiary designation tie in to my estate plan? For example, we had a lady that had come in to see us, and her husband had passed away. And we didn't do their estate planning on the front end, but she had heard that we do a lot of this type of planning, and so she asked, can we help with the estate administration? And we do that as well. And so we did go through this process with her, and we started gathering the different assets, and we found that there was an IRA that her husband had before he passed away. And so we went to the IRA company and we said, I'm Daniel Rhodes, I'm representing Miss Betty Smith. Her husband has passed away, and she would like to collect on this IRA. And the annuity company said, well, Mr. Rhodes, there's a little bit of a problem. Betty Smith is not the beneficiary of this account. Jane Smith is the beneficiary. Now, Jane Smith was the ex-spouse from 14 years ago. And so, being the dutiful attorneys that we are, we went to Miss Jane Smith and we said, Miss Smith, there's a little bit of a problem. John's passed away, and it seems he's left you as the beneficiary on this account. And she said, well, I always knew he still loved me. Well, we don't think that John still loved her. We think the attorney that helped him do his will didn't know that his job was not to create a piece of paper. His job was to put together a plan that cohesively tied all of the assets carefully to this plan. So this was a true story. This lady lost $90,000. We had another instance where a younger lady had come in to see us. Now, this young lady had been diagnosed with a terminal illness. She was not expected to live very much longer. And she was afraid that if she left anything to her minor daughter, that her ex-husband would gain control of it. And that's typically what would happen. And so, being afraid of this, she went in to see another attorney before she saw us, and she said, I'm really nervous. I don't want anything to go to my minor daughter because I'm afraid that that ex-husband will gain it and waste it and won't use it for her. And so the attorney said, here's what we'll do. We're going to draw up a will, and it's going to leave everything to your sister, and then your sister can use it how she wants for your daughter. And the lady thought, well, if that's what you think is the best way. So they put that plan in place. But after a little while, that lady got a little nervous about that plan, and she wanted a second opinion. She came in to one of our workshops, actually, and came in for a free consultation. And when she came in, we did for her exactly what we will do for you, which is ask a lot of questions. We want to make sure we understand everything. So in this scenario, we found out about her illness and how she was not expected to live very much longer, and also about her minor daughter and her ex-husband, who she was very afraid of taking control of the assets of that minor daughter. And we found out about her sister that she trusted, but she just wanted to make sure things went properly. We also asked about the assets, and we asked her what sorts of assets and where they were. We found that she had a 401k and a life insurance policy. And we asked her, who are the beneficiaries on these assets? And she said, well, I don't really remember. I said, well, we believe you, but we need you to go back and check. And so she did go back and check, and she came back to us and she said, I left it as my daughter. And that's very typical. It happens all the time. And so even though she had a will that said everything goes to her sister, it left out the two largest assets of the estate that would have gone to that daughter, where the ex-spouse would have possibly gained control of them again. And so for her, we used a different type of tool, something called a living trust. Essentially, it was her rules. She had the ability to set up this trust that said, everything in this trust is going to be for the benefit of my daughter, and my sister is going to manage it, but she has to use it for the benefit of my daughter. And then we went back and we changed the beneficiary designations to that trust. So when she passed away, the assets would go to the trust and the sister would have to manage it for the benefit of the daughter. The good news from that story is that lady actually got better and she didn't pass away. And this was over 10 years ago, and so the plan has changed a little bit. So even in our line of work, we sometimes see happy endings. So the will has all these problems that we talked about, but it also has one more huge problem that we haven't even hit on yet, and that is a will requires probate. If you're electing to use a will to pass your assets, you're electing into the probate process. And I always say that a few times because inevitably we'll get the question of, well, not my will, right? Because I don't have a lot of stuff, or I don't have kids, or whatever the reason. The answer is if you are utilizing a will to pass assets, you are electing into probate. So what is probate? To go through probate a little bit, I'm going to follow a different John and Betty through their lives. This is John and Betty Jones. We know a few things about John and Betty. They have a daughter, Susan. She's sweet and cooperative and will do anything that they ask. And then they have one other child, Bubba. Now, Bubba's not quite so cooperative, and in fact, he causes a lot of the issues in the family. What we found is most families have some sort of Bubba. Whether it's a child or a sibling or a niece or a nephew, there's always a Bubba. We also know that John and Betty have hit retirement age, and they want to do some things. They want to exercise more, they want to go on some good vacations, and they want to put together a plan of what happens in case one of them passes away. And so they go see the attorney they most recently dealt with, who happened to be their real estate closing attorney. They said, I want to put together a will that says that everything goes to my spouse, and if not, I want it to go equally among the kids. And so they put together a will that just said that, and they executed that day. And they were feeling pretty good because they got that done. Something off their to-do list is done. They go home, get up early the next morning, and start exercising. What happens? John has a heart attack. So now what Betty's left with is a situation where she doesn't know who to turn to, because that attorney that helped them draft the will is not an attorney that will help through the estate administration process. So what does Betty do now? In this case, Betty decides she's going to try and handle it herself. So she takes the will down to the bank and she says, I need to pay for John's funeral. I need to access his account. I'm listed right here as the executor on the will. And the teller will say, I'm very sorry for your loss, but before we can let you access that account, we have to know, has this will been probated? Because before the will is probated, all it is a piece of paper. It has no authority to allow you to act. And so what is probate? Probate is the court determination of whether or not a will is valid. That sounds pretty simple on its face, but really what that means is a petition has to be filed with the court, which means you usually have to hire an attorney. And once that petition is filed with the court turns around and it does something really strange. It invites anyone to participate that could have inherited if John didn't have a will and asks them what they think about the will. And so in this case, Betty's not the only one that gets to participate, even though there's a will that says everything goes to Betty. Instead, we also have to ask Susan and Bubba what they think about the will. Sometimes we have to ask grandkids what they think, sometimes siblings, sometimes nieces and nephews, and in some extreme cases, cousins that you've never even met, and ask them, what do you think about this will, where you're not getting anything? Well, what do you think they think? They don't like it. They want something. And so what a probate really is a hearing to accept challenges, to turn this into a full-blown lawsuit if any one of those people invited wants to contest it. And so we worry about this in every single situation. Now, it's unlikely that someone who comes in to contest the will would win, but we still have to spend sometimes thousands of dollars to protect the will, even in those situations that they're unlikely to win. And what's more than that is not just the financial side, but what about the family harmony? Once two sides of the family fight at a death time like that, they're never going to talk again. And so we've just lost that family harmony that we worked so hard to preserve over the course of our lives. So we worry about this in every single probate. There are certain situations where we don't have to worry because we already know there's going to be problems. For example, second marriage situations. Let's say that you've been remarried for quite some time and you've got children from a previous marriage, and your children are financially stable. They don't really need much help from you. And so you want to make sure that your spouse is going to be taken care of after you pass away. And so you decide, I'm going to leave everything to that spouse. If you do that through a will, when you pass away, that spouse is not the only one that gets to participate. We also have to invite the children from that previous marriage and ask them, what do you think about this will, where this new husband or this new wife is getting everything? It's a slap in the face to those kids on some occasions. And it really is an opportunity for that ex-spouse to come back in and whisper in the kid's ear and say, this isn't right. You deserve to get some of that. You need to make this hard on that person. And so they can check a box and turn it into a full-blown lawsuit. And so we worry about that in second marriage situations. Another situation is leaving somebody out, or just leaving somebody less. Maybe you've given loans to your children throughout their life, or one child in particular, and so you decide, I'm going to try and even it up when I pass away. Well, if you do that through a will, both of the kids would have to sign off saying, yeah, I agree, he loved Johnny 25% more, or whatever it is. And so it creates animosity at that worst possible time between siblings. Another situation we run into is if we have young or disabled heirs. In this situation, during a probate, the court will have to appoint a guardian ad litem to represent their best interest. And what that is typically another attorney. I'll be the first to tell you, the more attorneys you get into the courtroom, the more expensive it'll get. And what's more than that, even though it sounds good to have someone representing their best interest, because we've never met this attorney, we have no idea what sort of hoops we'll have to jump through. Even a surviving spouse would have to jump through these hoops. And so it can be an extra amount of work to have during this process, and an extra amount of money. Couples or individuals with no children. This is where we have to go and find the heirs at law that may be further off, that maybe you don't know. Maybe it's the nieces and nephews. But again, maybe it's that cousin, one you've never met. They're thinking, man, I can check this box and maybe they'll give me a few $1,000s to go away. And any good attorney will say, yeah, go ahead, pay him a few $1,000s. It's much more worth it than the full-blown lawsuit that will come out of this otherwise. And so, though we worry about probate in every situation, these situations we know we're going to have some severe issues. Probate can also be pretty expensive, between the court fees, the attorney's fees, maybe executor fees. In South Carolina, we also have a probate fee that's based off the size of the estate. It starts at a few $1,000s, and it goes up to many thousands of dollars. And so it's something that we are electing into by using the will, is all of these fees. Probate takes time. In Georgia, there's no prescribed amount of time that it can take, but even in the best situation, it takes several months, 3 or more. In the worst case situations, when we have creditors or disputed situations, it can be over a year to settle an estate. In South Carolina, we have a statutory 8-month-long period that we have to deal with the court. And that's just the statutory portion. That doesn't talk about the work on the front end to get to that portion, and also the work afterwards to close everything up. And so this is a lot of time we're having to have our family spend right when we've passed away, right when they're trying to grieve. And instead, they're having to deal with the court for months on end. If you have real estate in multiple states, we could also have to do probate in multiple states. If you've got real estate maybe in Augusta that you live in, your primary residence, maybe a rental property in North Augusta, and then maybe you inherited some land up in Ohio, some farmland. Well, when you pass away, then we're gonna have to probate in 3 different states. And that's, again, more expense, more time. And after we get to the probate portion, we've still got to go through and do the actual estate administration, go and find all the different assets. And so, we're talking about the deed on the house, the bank accounts, the life insurance policies, the safety deposit box, all of these different little things. And where Betty probably had a pretty good idea where most of them were, she's grieving right now. She's not operating at 100%. She's having a hard time even doing the littlest things. And so it makes it very, very difficult to go through and do all of these little things and track them down. And then once we track them down, we have to move them over into Betty's name. And again, some of that is fairly simple, changing a bank account, whatever. But what about the deed on your house or the title to your car? How do you handle that? That's something that can be a little bit more difficult if Betty doesn't know who to turn to and ask. So it's very frustrating and very hard on Betty at this time when she's just lost her partner. After Betty goes through that process, she still has to deal with the IRS. She has to file a final income tax return. Depending on your tax preparer, that may be simple, it may not. It may be that John was doing the taxes every year up until he died, and now Betty's left with a box of receipts and has no idea what to do with it. And so she doesn't know who to turn to ask these questions. And also, the biggest question of all for all of our clients when someone passes away is, how much do I owe in death taxes? What's the estate tax? The answer is most of our clients don't have to worry about the estate tax anymore. But if they don't know who to turn to ask that question, it's something that will keep them up at night for many nights in a row. And so it's nice to be able to turn to someone and say, how much is it? And they go, nothing. So once Betty's got the whole estate in her name and got all of the probate and estate administration settled behind her, she goes on for a while, but then her health kind of takes a turn. And in fact, it takes a real turn for the worst. She develops Alzheimer's. And so one of the big questions is going to be, who's going to make decisions for Betty? So, when we talked about this plan they put in place, we didn't really talk about them having power of attorneys in place. And so since she didn't elect who she wanted to make decisions, we're going to have to go through a court proceeding called a guardianship or a conservatorship. And that's a pretty tough process. It's a lot like a probate, but during life. And it takes some time and it takes some money. But what's more than that is it's hard on the person that's trying to help you. And it's hard on you, the person that needs help. And so it's just a bad situation all around that we're stuck with just because we didn't have a little bit more documentation on the front end. But what may be the bigger problem is the cost of long-term care. Right now, the cost of care per month for an individual for a nursing home in our area is between $7,000 and $8,000 a month. So we're talking between $80,000 and $100,000 a year. That can eat up even the largest estates very, very quickly. And so who pays for that? Your Medicare does not cover that, except for 20 days and up to maybe another 80 days for rehabilitation care. But after that, they're done. So that's 100 days possible. That's not a long-term solution. Your regular health insurance does not cover that. Now, there is a type of insurance called long-term care insurance, which I'm going to talk about in a little while. But for now, let's assume that Betty doesn't have that. So what we're left with this plan that she's got in place is not only has she elected in a probate, but she's also elected in something called the spin down, which is I elect to spin my assets down to near zero so that I can qualify for a government benefit. For our veterans, there's a benefit called aid and attendance. And what that is a monthly benefit that can pay for in-home care, nursing home care, or assisted living care. And all that you have to do to qualify for that is a certain resource limit, so you'd still have to spin down, but you have 90 days of active duty with 1 day being during a period of wartime. So if you fit that, you can spin down and qualify for that benefit. For everyone else, we're left with the Medicaid program. What that is I elect to spend to near zero so that the Medicaid program will pay for my nursing home expenses, not in-home care and not assisted living, just the nursing home. And so there's a few consequences to this spin down that you've elected into. And that is, for one, it's not just your assets you have to spin down. It's also your spouse's assets. And so while one of you is in a nursing home getting care, the other spouse is living in virtual poverty. So it's very tough on couples when we have to have a long-term care situation like this. Also, we've been talking about how do we leave stuff to the kids. You don't have to worry about that anymore. There's not going to be anything left. But what may be the biggest concern for a lot of our clients is what happens if I spin down and then the government program changes, or I need some kind of supplemental care that isn't covered by the plan? Who's going to pay for that? Then we're left in the awkward situation of having to ask the kids for help, having to ask those kids for money. So that's a tough situation that nobody really wants to be in. So after Betty's in the nursing home for a little while, she does also pass away. What a lot of people don't realize when I start talking about probate is with a will plan for a couple, we're not talking about just one probate. You're actually electing into two probates, a probate at the first death and a probate again at the second death. And so we've got that expense that's associated with it. And again, in South Carolina, we're hit with that fee based off the size of the estate again. But again, you're going to have other court costs, the attorney's fees, executor's fees. But we also are going to have another chance for fights because now we're inviting again those people and we're asking them, what do you think about this will? And so when mom and dad aren't there, that's when the siblings really are going to fight. That's when we're going to see them have a lot of issues. It's also going to be more time. Again, South Carolina, we've got that 8-month requirement there. And also, if we've got real estate in multiple states, probate in multiple states again. So there's a lot of issues with that. And whereas Betty knew where probably a lot of the assets were, the kids often have no idea where any of the assets are. And so we spend weeks and months trying to recreate all that information, trying to find the safety deposit box or the life insurance policy or where the bills were getting paid out of or whatever it is. And this is all at a time when mom and dad are no longer there. The kids are having to work together like they've never worked together before. And it can be a very, very tough situation. So those are all the problems of having a will. There are some problems with not having a will as well. And in fact, it's all those same problems, but a few more. We still have to probate, but probate is more complicated because you didn't say where you want your assets to go. Now the state says where they go. And they don't usually go where you think they'd go. If you pass away, if you're a couple and you have children, your spouse doesn't get everything. Your spouse may get 50%, may get 1/3, and then your kids will get the other 50% or 2/3. And so that can create a lot of problems. Now the kids own part of the house. And we're not only talking about adult children. Your minor children could also be in this situation. So it could be that your spouse owns half the house and the kids own the other half of the house, and we have to go through a court proceeding so that we can sell the house and move to another house. It creates a lot of issues because the probate court does control the assets for those kids until they reach 18. And then once they reach 18, they have control of them. But what may be the biggest problem for our younger couples that have minor children is because you didn't say who you want to take care of your kids if something happens to you, now the court has to say it. You're going to have your two sides of the family trying to figure out who's best. And sometimes that can be a really bad situation because everyone thinks they're best. And so we're left in a pretty bad situation just because you didn't say who you want to take care of the kids. And so our younger couples with minor children are more at risk by not having anything in place than our older couples from this standpoint. So these plans that you have in place were probably fairly inexpensive on the front end. You know, a few $100 for a will, nothing for a no-will plan, but over the course of your life can end up being fairly expensive. Between a probate at the first death, a probate at the second death, maybe the cost of long-term care along the way. It can eat up your entire estate to where there's nothing left. And not only is it expensive from a financial standpoint, it's also emotionally burdensome because we've got to deal with the estate administration and possibly the fights at the first death and again at the second death, and maybe going through guardianship and conservatorship if you lose capacity. These plans that you have that were inexpensive on the front end were really cheap. You know, they could end up costing you everything you have. And so we think there is a better plan out there. And it's something that we refer to as a total plan. It's not just a piece of paper. A good plan will help you preserve that information that you have in your head. So we're going to get it out of your head so it can be preserved and into a system and into someone's hands that can act as a stand-in for you when you pass away. So that your family knows who to turn to, someone that they can trust because they know that you trusted them during your life, and someone who can access that information and help them through this hard process. A good plan can 100% elect out of probate. We no longer have to ask anybody what they think about your plan. A good plan also covers what happens before you pass away, as well as after you pass away. And so if you need help during your life, we've appointed somebody that can do that, and it's someone you choose, not the court chooses. A good plan can help protect your assets in the event that you need to go into long-term care. We can protect your assets 100% if we do a little bit of pre-planning. We're going to talk about that in a few minutes. A good plan can also help you eliminate estate taxes. Now, most of our clients don't have to worry about estate taxes anymore, but if you're one of the lucky few that does have that problem, we can help you reduce or eliminate that with proper planning. But for all of our clients, we can usually help a surviving spouse avoid many thousands, sometimes hundreds of thousands in capital gains tax, depending on how their assets are structured. So we can do that for most of our clients. A good plan is personalized to you and your family situation. It's not one size fits all. A good plan also has a mechanism in place to stay organized over time, so you don't just set it on a shelf and forget about it for 10 years. You know, as things change, we want to make sure we have the ability to update this plan. So when we talk about a total plan, what we're really talking about is you making your own rules, which we mean creating a trust. Now, most people have heard the term trust and it's somewhat nebulous. The first way to explain it is it's your rules. You set it up and you get to say what happens. But what's more than that is it's an ability to organize your assets now while you're healthy and alive and capable and let them stay organized well on into the future. While you're alive, you typically accumulate all these different assets that seem very well organized to you. But then when something happens and you're no longer there, those assets don't seem so organized to anybody else. You know, it doesn't make sense as to why you had this bank account over here in California when to you went to college in California. It made sense to have that bank account. You know, and so it can create a lot of issues. But what the trust can allow you to do, if we compare it to something you're a little bit more familiar with, kind of like a wagon. During your life, if you were to purchase a wagon, you can put your stuff into the wagon. So if we create a trust, we can put your assets into the trust. And while you're alive, who pulls the wagon? You do. It's your trust. This is not a trust where there's some professional trustee involved. We're talking about you being the trustee, and you get to be able to control these assets. And also, while you're alive, who gets to play with the stuff in the wagon? Who gets to use the trust assets? You do. It's your stuff. And so you stay in complete control. But if you become incapacitated, you say who steps in immediately. We don't have to go through a court proceeding or anything along those lines. And so the person that you name, that you trust, will step in and continue to use those assets for you during your life. And then when you pass away, they'll have the ability to administer those assets as you say. Another way to think about a trust is to compare it to a will. So what is a will? A will is a document that you have drawn up during your life that says what happens to your assets after you pass away. Now, I will caveat for a second and say some of you may have what's called a testamentary trust inside your will. And what that is a trust. But because it's located inside your will, it can't be activated until we go through the probate process. And so it has a lot of the same benefits of a living trust, except for it still has to be probated. So a living trust is better than the will because we activate it while you're alive. And so when you pass away, we don't have to worry about activating it later. And so since we activate it while you're alive, it says what happens while you're alive. You stay in control. You're able to spend the assets, the principal or the income, and you can amend or revoke it at any time. So you're still in control. The idea with the living trust is it doesn't change your day-to-day life either. You still have the same property taxes that you pay, so you still qualify for the same homestead exemption. You still file the same income tax return each year, and you don't pay any additional taxes, and so there's no change from your day-to-day life. But again, because we activate it while we're alive, when you pass away, we avoid probate, which means we don't have to ask anybody what they think about your plan after you pass away. Instead, the person that you say just implements it. And so we avoid the chance for fights. We avoid the delay, the time that it takes, 8 months again in South Carolina. We also avoid, the expenses that come along with that and the burden of having to do all of these things right when they've just lost a loved one. And because we've set it up while you're alive and it says what happens while you're alive, in the event that you do become disabled for whatever reason, it says who steps in at your incapacity. It's someone that you nominate, and they take over control and continue to use these assets for your benefit. Because we're doing this ahead of time, we're doing this now as opposed to doing it later, we're taking off a lot of work off the heirs because we're organizing it now. And so your heirs will be really grateful that this is in place. We can also make sure that in the event the estate tax does get put back in place for most of our clients, we still have provisions to take care of that. Again, a good system is going to check on that from time to time to make sure that we don't have any issues. But even so, we want to make sure there are provisions in place just in case something happens. The total plan will also be personalized to you and your family. This is not that one-size-fits-all that I was talking about earlier. Instead, we're going to spend a lot of time with you making sure we understand what your goals are and making sure you understand what opportunities are out there to help you protect your family down the road, even after you've passed away. A few examples of that. If you're trying to benefit a minor beneficiary, maybe it's a grandchild or something along those lines, where if you leave it in a UTMA account or a 529, they gain control of it, at a young age, maybe 18, maybe 21, when they're still legally insane. We want to maybe change that so that they take control at maybe 25, maybe 35, maybe 85. It's your rules. You get to say what it is. It's very flexible. And until that time, it's still there for their benefit, being managed by somebody you trust to manage it for them, rather than them having control. Some of our clients come in and they have individuals that have special needs, a disability that's not going to go away over time. And these individuals typically qualify for some sort of government benefit. And these government benefits are great. And if we leave even $1 too much to this special needs individual, they'll get kicked off of this government benefit. But the truth is, as great as these government benefits are, they typically don't allow for a quality of life that we typically would want for our family. And so what we have is an ability to establish something called a special needs trust that will allow you to leave as much money as you want there to be as a supplemental fund for that special needs individual and not count against them one bit, but can still be used for their benefit over time. So these can be really, really powerful for those special needs individuals. Another situation that we run into is when there's someone like this fella, somebody who has problems. Maybe it's drinking problems, could be drug problems more so today. And so it's something where we might want to try and protect them from themselves a little bit. This is a situation where we might include using a professional trustee, like a bank or another type of professional. And so we can make sure that that money is protected for them over time. It may also be that they're just not great with money. Or maybe it's they're married to that daughter-in-law that you want to make sure never touches a penny of your money. We can help make sure that happens. And so we have that ability going down the road into the future. Another good example of what we would want to have some extra planning in place for is for business owners. If you've got a small business, a family business, it's something that's brought great wealth to the family over the years. And we want to make sure that it continues to bring wealth to the family down the road. But without careful consideration, it's something that can tear the family apart or simply disappear after you've passed away. And so we want to make sure that we've got some very careful planning in place to make sure that we've got a plan of how to get it to the next generation. A lot of times you'll have one child that's in the business with you and another child that's never set foot in the door. And when you pass away, that child that's never set foot in the door says, all right, cash me out. Most businesses can't afford to pay a shareholder 50% overnight. It's something that will tear apart a business. And so it needs careful consideration. We've been doing this for over 40 years. We've had some experience in doing this. And so we can help you plan for the next generation, whether it's your family, a key employee, or maybe just selling it outright to another business. Another situation we run into is family vacation land, whether it's a lake house or a beach house, something along those lines where you use to bring the family together a few times a year. And you hope that it will continue to bring the family together after you pass away. But the truth is, after you pass away, the kids aren't going to use it the same way. They're going to use it more like a timeshare. One of them's going to say, I get the entire summer, you can have January. Also, I hope you can afford the property taxes. We get into a situation where without proper planning, it can create animosity among the siblings, and also maybe just go away because we didn't think far enough ahead of how to continue to maintain that house. And so that takes some careful planning that we want to make sure we understand and help you make a decision on. Another benefit of a total plan is that we can not only say who gets the assets, but also say how these beneficiaries can maybe be protected down the road well after you've passed away. For example, it may be that one of your children has health issues and they get sued so that they can pay those bills off. Well, we want to make sure that those assets you leave them don't end up getting eaten up by that cost. Or maybe one of your children gets divorced well on down the road. Again, we want to make sure that the assets you leave them aren't subject to marital division. We don't want the ex-spouse taking half or anything along those lines. So we have the ability to protect these assets from any creditor that your child may have now or in the future. And that's a huge part of our planning in a lot of cases. But enough about the kids. What about you? How do we protect these assets for you while you're alive in the event that you need long-term care? The answer is we're able to protect 100% of these assets if we pre-plan. If we do things ahead of time, we can make sure that your entire estate can be preserved even in the event that you need long-term care for a long period of time. With this, we typically are talking about another type of trust. It's called a long-term care or an asset protection trust. This type of trust allows us to move your assets over into the trust so that they no longer count against you. You get to stay the trustee though, so you're still in complete control of the assets. By putting this plan in place early enough, we elect out of the spin down, which means your spouse doesn't have to live in poverty, which means we don't have to worry about asking the kids for any money, and it means that we might be able to leave the kids something after you pass away. And so this again is different than the long-term care insurance. Now, even if you have a situation where you need to go into care tomorrow, we can usually protect about 60% overnight. And so we've gone from a 100% spin down to just a 40% spin down. That's pretty good. And so if you were a loved one or in a nursing home now, but there's still assets left to protect, we can still help. And so when we talk about what government benefits you can qualify for by protecting these assets, for our veterans, again, it's that VA aid and attendance benefit. For that, we have to put that in place 3 years before you need the care, if we want to get 100% protection. If, on the other hand, you are not a veteran and you don't qualify for that benefit, and we have to look at the Medicaid benefit, we have to do that 5 years in advance. And so we want to try and get this in place as soon as possible. We start recommending this planning at 65. If I could tell you the exact day you were going to need nursing home care, I could tell you the exact day we need to put this trust in place. But I'm not that good, and so I start recommending around 65. Now, this trust is not the same as long-term care insurance. It's different. What it is the ability to qualify for these benefits. For a Medicaid benefit, it pays for your nursing home care over your income. Your Social Security and your pension still has to go to the nursing home, but your savings does not because the Medicaid program pays for it. And with these nursing homes, we're not talking about, the bottom tier state-run nursing homes. Most private nursing homes accept Medicaid. The long-term care insurance, on the other hand, is something that pays for not only nursing home, but it can pay for in-home care or assisted living. And so if you have that in place, or if you're interested in it, that's something we can help you do. Part of our team will be able to help you look at the long-term care insurance that you have, or maybe look into getting new long-term care insurance. If you come in and you've got long-term care insurance that pays $450 a day for life, you don't need the long-term care trust. And so we would go through that together and see what makes the most sense for you. And then we would make a recommendation. So when you come in to see us, we're going to talk about your goals and we're going to talk about your options. And we're going to make a recommendation to you at that time. And so most of our clients that are under the age of 65, we're probably going to be recommending that revocable living trust. And what that is the ability to pre-organize assets and do things ahead of time so that your family doesn't have to do it down the road when you've passed away, to establish a stand-in for you to help your family when you're not there, someone that your family knows they can trust because you trusted them during your life, and so they know that they can turn to them when you pass away. Also, we can help a surviving spouse save sometimes hundreds of thousands of dollars in capital gains taxes, so that can be a huge benefit. it can help protect your beneficiaries well after you've passed away from any creditors they might have. But the biggest thing that revocable trust can do is avoid probate. We don't, again, have to ask anybody what they think. And so that's the revocable living trust. For our clients that are 65 or older, we may recommend the asset protection trust. It has all the same benefits of a living trust, but it has the added benefit of protecting your assets from the cost of care. Now, one of the things that we don't do is we don't charge based off of the size of your estate. We charge based off of the amount of work that we have to do to get you to your goal. And so when you come in and we sit down and talk, we'll go through exactly what we are recommending to you. And from that point, we will give you an exact cost. The nice thing about the trust is it's a one-time fee. So when you come in, we'll tell you exactly what that looks like for you. We're not playing hide the ball. But what I can do is give you a little bit of a ballpark of what these plans run before you come in. If you come in and you say, you know, Daniel, I understand that a will has its drawbacks. We have to go through probate, but I think my family can handle probate. That's perfectly fine. We do will plans as well. We do very complete will plans that avoid most of the problems of a will, but it still is a will, so it requires probate. But otherwise, we can get a lot of the same benefits we were talking about. That will plan is a very complete plan. It includes a financial power of attorney for you, as well as a healthcare power of attorney, as well as our recommendations of getting all your assets tied to the plan so that we don't have beneficiary designations going to the ex-spouse or something like that. That plan typically runs about $850. Now that's per person, and so for a couple that would run $1,700. For most of our clients, we're going to recommend one of the two trust plans, the long-term care trust or the revocable living trust. These are a little bit more of an upfront investment, but we do look at them as investments. They will find ways to pay for themselves many times over, typically over the course of your life. And so they are a little bit more than a will. With the cost of long-term care being between $7,000 and $8,000 a month, this long-term care trust will pay for itself in 1 month if you ever end up needing long-term care, and it will continue to pay for itself every month after that. This trust typically runs $5,900. What that trust plan includes is the trust, plus the power of attorneys that we talked about before, the financial power of attorney and the healthcare power of attorney, as well as something called a pour-over will or a safety net will. And what that is in the event that you have something that is not tied to the trust when you pass away, the will grabs it and moves it to the trust. It is a will, so it requires probate. Our goal is to not have to use it, but we want it there just in case. We also include instructions on how to have all of your assets tied to the trust. So we'll do as much as we can, but there is some homework that you'll have to do. Again, that's doing stuff ahead of time. And that $5,900 is for a couple or an individual. It does not get doubled there. For our clients that are under 65, we'll typically recommend the living trust plan, and that costs a little bit less. That typically runs $3,900. And that includes all the same stuff that we talked about for the long-term care trust. It includes the power of attorneys, the deeds, the instructions on how to tie your assets to it, so all of those things. So these plans are very complete plans. And again, with the cost of a probate being between $2,000 and $3,000 in a best case situation, and having possibly 2 probates over the course of a couple's lifetime, these trusts pay for themselves in that way as well. And so when we come in, we'll talk to you about the different benefits for your situation and explain what we think the benefits are. And then we'll make a recommendation to you at that time based off of how much work we'll have to do. And we'll tell you the exact cost of what that will be. And so I would encourage all of y'all to come in and take us up on a free consultation. There's no obligation whatsoever for you to come in. And so we're happy to get to know you a little bit better and let you get to know us a little bit better. And so if you're interested in coming in for that free consultation, please sign up on our website or call into our office, and we'll make sure we set you up with me or one of the other attorneys in the firm. Thank you for watching.